Hello, everybody. Welcome to this month's Specify and Practice Community. So with that, I do want to hand it off to our co-chairs, David Stutzman and Lewis Metcalf, to get started with today's session. So Dave and Lewis, over to you.
Thanks, Matt. This is Dave coming to you from southern New Jersey. And a bit gloomy here today, but we're getting ready for the rain that Cleveland is sending our way. Lewis?
Hi, I'm coming to you from the Nashville area, and it's a bit cloudy here too. And I want to introduce or reintroduce our guest speaker today, Josh Flowers, who is with let's see, they've changed their name now, HBG Design. Is that right, Josh?
That's right.
Okay, in Memphis, Tennessee. And Josh and I did overlap for a while before I escaped from Memphis and moved to Nashville. And he is a very pleasant and intelligent person. And we were remarking beforehand that one of my regrets is that I don't get to spend enough time with him to kick ideas around and just talk. Josh is unique in the state of Tennessee in that he is both a registered architect and a licensed attorney, and so he is general counsel for HBG Design, but he is also a certified construction specifier and a certified construction contract administrator. In other words, Josh's primary hobby is taking tests. Say hi, Josh.
Hi, thank you, Lewis, and hello, everyone.
So today we're going to talk a little bit about construction warranties and how to, what they entail and their effects and so forth, and get a little bit into how to specify them. And our goal here is, of course, not to give direct legal advice. Josh would want me to say that for his behalf, if nothing else, but to raise maybe your consciousness level so that you know what questions need to be asked and what things need to be investigated. And the watchword for our program today is read the fine print.
Just like any contract, correct?
Exactly. Any legal document. So, Josh, what is a warranty?
Well, the short version is that a warranty would be a promise that certain facts are true, but then you get into it's always subject to specified limitations. So, we said just a moment ago to read the fine print. A lot of that is all of the limitations, exceptions, and other qualifiers that make up the warranty. So there's a promise of some type, but then it is backed up by a lot of exceptions and other restrictions that have to be evaluated. So that's the shorter definition, and then we'll start exploring what that means, especially as it's applied to construction projects.
Is there a difference between warranty and guarantee?
Yes. The guarantee would be something that if there's a third party who assumes responsibility, that is more of a guarantee. So, if the contractor is providing a bond, there's a surety that is providing a guarantee on behalf of the contractor. So there's a third party involved when you have a guarantee. The warranty is the direct relationship, so that there's an assurance by the primary party. In a lot of cases, it's the contractor providing a warranty directly to the owner. So there's a little bit of a difference between the two, but the main idea is with a guarantee, you're asking who is the third party and who are they providing their assurance on whose behalf. So trying to make sure you have all of the parties connected when you're thinking about who is providing the warranty or the guarantee in the particular circumstance.
So Josh, here's one example. The difference, the guarantee that I like to use is think of it as a parent co-signing your children's auto loan becomes a guarantee.
Exactly. And that's a good example because it gets into, if you are that third party, what assurances do you want from the party that you're providing that on their behalf? So when you're talking about sureties, they require a lot of documentation when they're providing something on behalf of the contractor. So there is that relationship. They are providing the protection, but they're also seeking protection for themselves. So there's a lot of documentation that has to be evaluated, particularly if you're talking about bonds. The warranties, you may be able to find those in the contract documents and in other locations, which is what we'll explore as we move through this discussion.
Kevin points out that guarantee, I should have spelt that with a Y on the end, and because technically that's right. Although you see the word spelled with two E's informally on a lot of consumer goods and so forth. It may say warranty or it may say guarantee, although technically with the two E's, that's the person who is being protected. And it's interesting that the words warranty and guarantee are actually derived from the same word. But in French, they stick a G in front of the W sound. How about warranties and insurance, Josh?
Right. So before we move on, we're kind of getting the ground rules out on the table, and wanted to add insurance into the picture. So we talked about the possibility that there is, if someone's providing a guarantee, there's a third party who may be involved. There may also be insurance requirements, which is different from a surety or someone who may be providing a guarantee. So one of the things that we talk about a lot, if you're providing a warranty, is it also insurable? So you could provide a promise, but is it backed up by an insurance policy or by some other ability to perform what's required by the warranty? So that's one of the considerations that you'll see a lot when you're talking about warranties, is that it may state something, but how is it backed up, and who is providing the backup that's required? So if insurance is part of the picture, one of the considerations is what does the insurance policy state, and who is being insured. So the design professional has a lot different requirements from the construction contractor. And a lot of times, if you're looking at design professional agreements, sometimes you'll come across agreements that have been drafted more for a construction contractor. So there may be warranties that would work for the contractor, but would not be insurable for a design professional. And one of the reasons for that, you can see the two different types of insurance that we're talking about in a lot of these cases would be either the professional liability insurance policy would apply, particularly if it's a design professional. The professional liability policy is what most often will insure their services. The contractor provides a general liability insurance policy, and the architect may as well, but they insure different things. And the thing to be aware of is that the professional liability policy typically will exclude what's referred to as contractual liability, and that in most instances will encompass warranties that may be included in the agreement. So it's an important distinction to be aware of. It's something that's coming up more frequently, and it's something that we wanted to have stated up front and keep in the back of our minds as we move through this.
When Josh and I were working together, we received a number of owner-written general conditions or contracts that we were having to negotiate, and many of them would state that the architect would guarantee that all the ADA regulations were met, or the guarantee that the code would be met, or both. And so we found it very successful in our negotiations to get such onerous language out of the contract by telling them that we can put that in, but it won't be covered by insurance. And they usually capitulated. So what does a warranty do? What are the effect? Why do we want one? And how does it affect the different parties?
So part of this, the warranty is there to provide the protection that the parties have determined is needed for the project. And a lot of this is that you're getting into comparison of what do different warranties do. So if you determine on a project that there is a warranty needed for a particular assembly, there may be multiple warranties that would be available, and you're trying to determine what language is involved in these different warranties to try to compare them. So the warranty is there to provide that protection. It's stated within the warranty. It provides those specified limitations. And beyond that, you're looking at how does it fit into the relationship of all of the different parties who may be involved. And we talked about this a little bit in the beginning. So there's someone who's providing the warranty. That would be the warrantor, the first item on this list. A lot of times the person providing the warranty may be the construction contractor, or it may be the manufacturer. So if you have a warranty provided by the manufacturer, they may be providing a warranty that the product is free from defects. But the contractor may also be providing a warranty for the workmanship. So there could be separate warranties working together to provide the protection that the owner requires for the project. And you get into looking at how those work together and making sure that they coordinate the way that you would intend for them to. So that's one of the things that may come up, is trying to make sure that the warranties, multiple warranties, work together.
And of course, we need to recognize that the manufacturers in particular, when they write a warranty, their primary goal is to limit their liability to what they think is reasonable or what they can afford. How does how do warranties affect the design team, who is not strictly speaking a party to the construction contract between the contractor and the owner? Are warranties a good way to evaluate products, the level of warranty that is available?
Well, it certainly is a consideration. You want to see what are all of the different components of the warranty so that you're comparing apples and apples. And it can be very challenging for the design team if they are the ones trying to identify all of the differences among different warranties that are being compared for possible selected products. So the design team may be involved in verifying that warranties are part of the documents if it's provided by the owner, but there's always that word of caution about actually writing a warranty, which sometimes may be requested, but if that happens, it sometimes can be an indication that it may be something that needs to be referred to the owner's legal counsel, or it may be something that needs to be coordinated more among the construction team. But the design team is definitely part of the picture. It's just something that needs to be determined depending on all of the circumstances.
Yeah,
and of course,
one of the things that we've seen happening recently, Josh, is that the design teams will use a particular manufacturer who tends to offer an extended warranty, meaning 5 to 10 years, both for material and for labor, to include those manufacturers in the specifications, listing their particular warranty terms as a means to force other competing manufacturers to provide the same warranty.
Right.
And then there are the companies that are fairly brand new, maybe have a new product that they're offering, and they've only been in business 2 or 3 years, and yet they will offer warranties of 10, 15, and even 20 years that I've seen. Mm-hmm. And
yes.
How believable is that is something that everybody's going to have to make up their own mind on.
One other thing, when we're talking about warranties with the design team, one thing that has come up more frequently is that you will see in the owner-architect agreement, sometimes if it's an owner-prepared form, there are more requests for the architect or engineer to provide a warranty that their documents do not infringe on intellectual property that's owned by third parties. And that can be very complicated when you're talking about professional liability insurance and other things. And when we're talking about electronic documents, that is something that is coming up more, is that the owner wants a request for the design team to provide that type of warranty. So if you see that, it's a question that needs to be resolved through insurance, because as we said, we don't want to provide those warranties, but that's something that a lot of people are seeing more frequently, which is different from these manufacturer warranties and other things that primarily involve the contractor. This is involving the work product provided by the design team.
And Lewis, I love Kevin O'Byrne's comment here. Hey, a 20-year warranty is worth it. After all, it's on paper.
Kevin has a way of cutting through the cloud with an essential statement like that. Well, let's talk about the different types of warranties and their periods. The contractor's general warranty is stated in AO 201 paragraph 3.5. And what's the period on that, Josh?
So
as a matter of fact, we can go over and look at it.
If you look at the language in A201, this is the statement of the contractor's general warranty, like Lewis was saying. And as the earlier comment alluded to, you're always looking for what is the time period associated with any warranty. And on this one, you can see that there is not a stated time period, but it would be governed by statutes in most instances. So if there's a statute of repose that would apply, that may be the time period that's associated with the warranty. The other thing is, what is the starting point for any time period? And with most of these, it would be substantial completion, but there could always be language contained in the warranty that would be some other type of starting period. And one of the things that we were looking at, if you're familiar with the newer AIA documents, you'll see the section AIA with section 352 at the bottom of this warranty, which states that the warranty has to be issued in the name of the owner. A lot of times there have been concerns about the starting period for a warranty requiring some type of signature, so the warranty does not start until someone signs off on it, or it is not assignable to someone else. So in a lot of instances, what the owner thought they were getting as a warranty that protected them, there may have been exceptions. So there's language intended to address those types of concerns. But in this instance, you're looking at a lot of times what is the location of the project and how does that affect the time period for this type of general warranty.
And Josh, when we rely on substantial completion, that can also get to be pretty tricky, especially with multiple work package projects or with multiple phases of a project, so that you may have multiple substantial completion dates as well.
Yes, and for phase projects, it can be very important to track those multiple certificates of substantial completion where they have different dates. So if the owner is wanting to have occupancy of a portion of the project before the entire project is finished, as David was saying, you may have multiple dates of substantial completion. So once the project is finished, if there's a problem that arises and you're trying to determine when did the warranty take effect, you may have multiple dates that would need to be coordinated, and there's a concern about would it be the earlier date or would you have to determine which portion of the project was subject to which particular certificates of substantial completion. So, a lot of times you think about completing a certificate of substantial completion is more about filling in the blanks, but now we're seeing with phase projects, there can be a very detailed description of the scope that's subject to that particular certificate. So that gets into more technical writing requirements than we've seen in the past with just completing a certificate of substantial completion. So it does get more complicated.
In particular, manufacturers of large HVAC equipment really want their warranty to start from when it's turned on, which is going to be well before substantial completion of the entire project, but they figure if it's running during the construction period, that's when the warranty should start.
Right.
Okay, are we ready for the next? I'm sorry I lost the audio for a minute there, and so we'll go back to, oh wait a minute, we need to go back to the preceding. There we go. So we talked about the manufacturer, the contractor's general warranty and its period, and you covered the statute of repose while I was away.
Yes, we did talk about statute of repose.
Okay. Well, that's all right. You don't need to revise that for me. So how do a manufacturer's general warranty differ from a special warranty, which is used now in that A201, in the new A201 paragraph that we just looked at?
Right. So as we were saying earlier, the manufacturer typically will provide some type of warranty, but there could be different warranties for the same product, or there could be multiple warranties that would apply to a single product. So there could be a warranty that would cover any defects in the product itself, or there could also be the contractor's warranty for workmanship that would apply in different respects depending on what type of product was being warranted. There could also be some type of special warranty that would provide some terms of the warranty that are required in the contract documents or required by the owner, or it could be something that the manufacturer has provided for every product. So it gets to be more of a comparison to determine among multiple warranties that could be available or applicable to that particular product, is the end result that it's providing the owner's desired protection. So that gets to be a big challenge when you're looking at, different warranties that are intended to work together, that have their own exceptions and other things that would apply. So that's one of the considerations that we get into a lot, is making sure that those warranties work the way they're intended.
Yes, for the owner's well-being and protection. David, since I was offline for a minute, did you address Alan and Edward's comments?
No, we did not. Did not get to those. So I'll go ahead. So Alan Itzkowitz is just stating part of the problem with the manufacturer warranties is that they claim to start at the time of delivery to the product to the project site. All the documents I write require warranty to start at substantial completion, sometimes multiple substantial completions, as stated. So is there a concern there, Josh, about how we might address those conditions in the specifications other than to recognize substantial completion as the start point of the warranty?
Yes. Well, there's definitely a concern, and it's an important thing to point out because the time of delivery, we were just talking about phased projects. So something could be delivered to the site because of available pricing, not necessarily when it will actually be incorporated into the work. So a lot of times you'll see that something was purchased and delivered well before it is intended to be incorporated. So a lot of time can go by before you reach substantial completion for those types of warranties. So trying to make sure that substantial completion is the date that applies to all of the warranties is usually the general strategy that you want to use. It's just a matter of trying to make sure that the person providing the warranty hasn't tried to make that exception to say that it starts at the time of delivery or any time, typically trying to make it earlier than substantial completion, because that way they've started the clock running before it's even incorporated into the work, which is when any defects would be discovered, or at least the earliest that you would expect that they would be discovered. So it's definitely something that has to be addressed.
Okay. Edward Eystone says, please address state requirements for providing a contract warranty. It's not the statutes are not really in that terminology. What the statutes say is that there's a time limit, an ultimate time limit, not just for filing, that's the statute of repose, but the statute of limitations, but there's an ultimate limit after which the owner cannot file a claim against the contractor or the architect, and they're usually the same period, and that's called the statute of repose. Tennessee has a very short one. It's only 4 years that can be extended in certain circumstances to 5. Mississippi is 6, but I know some states are 10 years or more. AIA publishes a list of all of those states, so that you might want to get a copy of that if you're doing work in other states to find out what their limitations are, because it affects the architect as well as the contractor.
Okay, I'd like to jump ahead in the questions too to another one from Kevin O'Byrne saying, given comprehensive protection of the general conditions correction period, he's not so sure how important a manufacturer's standard warranty truly is. Is that something that you might agree with, Josh?
I do agree to some extent, because in a lot of these conversations, what you're trying to get is something that is at the high level of what that question refers to, the correction of work period. And we are skipping ahead a little bit talking about that, but there's a different provision in the A201 that provides what's referred to as the 1-year correction of work period. And that is where, if anything goes wrong, the contractor has agreed to to remedy those issues if it falls within that 1 year period, regardless of whether it's a manufacturer issue, a workmanship issue, or something that would not be covered under other warranties. But then once you get beyond that, that's when all of these other things would come into play within the time period that you would want to determine based on the location of the project. So I think that there still is some significance to those warranties, depending on where it would fall on your timeline. So that's really the consideration that you want to look at is, does it provide anything beyond that 1 year correction of work period that would be desired, and is there a cost associated that would it be worth it?
Yeah, there's really no point in specifying a 1 year manufacturer warranty. That is absolutely. We need to pick up the pace just a little bit. Josh, you want to explain very briefly what the warranty provisions are under the Uniform Commercial Code?
So there's also the UCC, which applies to the sale of goods, and in general, anything that is sold is intended to be free from defects under the UCC. So if there is a problem with something that is sold, the UCC can provide protections, but it also has very specific rules that apply, and there may be considerations about how it would affect. We talked about delivery to the site. There may be other restrictions because it's dealing specifically with the sale of particular components, not necessarily how they are incorporated into the project.
Yeah, exactly. So it really applies only between the vendor and the contractor, or even the subcontractor. It doesn't really affect the owner can't claim under it.
Right.
Okay, and we looked at that. So, the correction of work period.
We were jumping ahead. So here you go, Josh.
Yes. So we have discussed this already, but this is where you will find the correction of work language in the A201, and that is what provides this 1 year period. So if you take a look at this, a lot of times you may hear this referred to as a warranty, and that is a common misconception, but this is specific contract language that's part of the contractor's agreement with the owner. So it's just an extension of the work of the project, and making sure that there is this 1 year period where the contractor will correct any problems that arise, and it doesn't differentiate among different components of the project, as we were saying earlier.
It's amazing. If you have something done on your house, the contractor is probably only going to give you a 1 year work warranty. However, in commercial construction, it's amazing how many contractors even, and even lawyers, other than Josh, of course, who do not understand that the actual period of the contractor's warranty is a multi-year that is defined by the statute of repose, and fail to recognize the first sentence here in paragraph 12.2.5 that says, nothing contained in this section shall be construed to establish a period of limitation with respect to other obligations the contractor has under contract documents. The establishment of the 1 year period for correction of work as described in section 12.2.2 relates only to the specific obligation of the contractor to correct the work and has no relationship to the time within which the obligation to comply with the contract documents may be sought to be enforced.
Mm-hmm. And we'll also point out, you can see in that language that 1 year period also starts as of the date of substantial completion.
Right. So in effect, it's a matter of the owner identifying any work that would otherwise be considered defective. So under the contract, the contractor has the obligation to correct that defective work.
Right. And so you want to keep that 1 year mark in mind for anything that is known, that it is communicated to the contractor so that it can be corrected under that 1 year correction of work period without going beyond that.
And the burden of proof that it's, if the contractor thinks that the failure was the result of extreme weather or abuse or vandalism or something like that, the burden of proof is on him to say, oh, it's not my fault. Whereas after the first year, the burden of proof now is on the owner to say that the work was defective originally.
Which can make the difference when you're talking about some of these warranty claims. Providing documentation can be a big challenge. So not having that burden really does change the position of the parties in a lot of cases.
My friend Scott Anderton from Birmingham, who is an excellent independent specifier, says state work in Alabama requires that the warranty be administered under the laws of the state of Alabama rather than Delaware, which seems to be a favorite.
Yes, and Alabama also has one of the longer statutes of repose, so it affects the time period significantly.
Do you know what that is offhand?
Alabama
Scott probably does.
15 years.
Wow.
So compare that to Tennessee, where it's 4 years, adjacent states. It can be very different.
Okay, so there's a problem, and and the owner wants to be made whole. We call those the remedies. So what kind of remedies are available under various warranties?
One of the things, the first one listed here, having a complete replacement or repairing the work is one option, but in a lot of instances you'll see that it may be subject to some of these exceptions. So they may provide what's referred to as materials only, or there could be other exceptions that it would not provide the full replacement. One of the other considerations is, it may not just be the particular product that failed. It may be the damage that was caused to other portions of the project. So if you're talking about some type of waterproofing warranty, not just the failure of the waterproofing itself, but the water damage that is caused to the project, are those types of instances covered within these warranties. So there could be more. Damage. Right. It's and consequential damages, we talk about that term a lot when you're talking about the extent of damages for the project and extending to lost profits and other things. But this is a different context because we're talking about, one particular product, but the consequence of that could extend to other parts of the project, other materials and other things. And you think about these other materials may have their own warranties, but you can imagine that they will exclude defects in other materials that cause the damage to those components themselves. So it can get very complicated when you're trying to sort out which type of warranty will provide some type of remedy when you have extensive damage to the project caused by particular failures.
And of course, some warranties have provisions for prorated use that if the if the warranty is for 10 years and the claim comes in at 5 years, you may only get a 50% payoff. Whereas one of the things about roofing warranties, most roofing warranties, are that they are pretty good about being no dollar limit. That if it blows off in a 20-year warranty, if it blows off in the 11th month of the 19th year, theoretically the manufacturer has to come out and completely replace the roof.
Right.
So,
and
so
we also
Josh,
have. Oh, go ahead.
Oh, yeah. Are there other potential remedies? We're talking about replacement or repair. Is there also a potential monetary remedy? For instance, if there's some failure where a repair might only just make, say, an appearance worse, might there be some monetary response?
There could be. And like we've been saying before, the warranty language will tell you, or in some cases try to obscure what actually is provided or what is actually covered. And that's where we get to this last bullet here about what are the claim procedures and how does that affect what type of remedy you're able to access, because there could be, replacement could be listed somewhere. There could be some type of monetary remedy that's provided within the warranty, but there are these procedures that have to come into play. A lot of times you look at the conditions that are placed on the warranty. So some type of maintenance, other sign-offs or other things that had to happen. And it doesn't just mean that if there was a failure of maintenance that caused the problem, but the maintenance may be a condition to accessing whatever remedy the warranty is intended to provide. So that's where you get into a lot of these complications and can be a very lengthy claim process to try to sort out. And like we said before, if it's a part of a bigger issue, some of these warranty questions can really slow down the bigger picture of a claim because it can be so time consuming to try to go through the process of trying to hold the warrantor to account.
Well, as David is fond of pointing out, roof warranties, some manufacturers, you may need to prove that you performed all the maintenance issues that are stated in the warranty, all the maintenance procedures, I should say, stated in the warranty to be able to collect on the warranty.
Exactly. And if there were 51 procedures and you only did 50, a lot of times it doesn't help you. You have to do everything that's required or you get nothing. And that can be very frustrating if you're on the wrong side of that type of decision.
And then there's the materials only warranty remedies. At one time, most of the EIFS manufacturers were like that if you could prove that their product that was installed on the building was in fact defective, but you had to prove that it was defective, they would give you a brand new bucket of stuff that you could use. ACM warranties are a bit like that, because the ACM manufacturers do not manufacture or take responsibility for how the panels are mounted on the buildings. They are only responsible for replacing individual materials for individual panels that might delaminate or discolor or whatever. Okay. So how do we specify the right stuff?
We finally got to the really important part. Sorry, Josh.
Right. Well, we've alluded to this, I think, as we've been going through these different discussions of what the warranties are. But the idea is that the warranty has to be stated somewhere. So there can be warranties contained in the specifications, or it may be something that is referenced within the contract documents in some particular location. We looked at the ones earlier that come from the general conditions. There may be other warranties that are part of Division 1, and there could be product warranties that are required elsewhere in the specifications. And we did mention earlier the word of caution about trying to create new warranties, which could take on additional liability for trying to write something, and then if there are problems later, how would that be interpreted if it was not working as intended, or as the owner
expected our third bullet
to.
there. Our third bullet. Yeah. But the first bullet I want to talk about a little bit, or get your opinion on. In Master Spec, a number of the sections require, and many of our listeners today are subscribers to Master Spec, a number of the sections have a statement in the informational submittals requiring a sample warranty form. And it appears that the idea is that the architect would take that sample warranty form, forward it to the owner, and tell them to get their legal counsel to look at it. The legal counsel would look at it and either approve it, accept it, try to modify it, or say, no, maybe you better buy a different product. But all of that takes time, and it's probably not a very practical approach. But what do you think about that situation, Josh?
It's very time consuming, and that's why a lot of times it can be impractical. But in those rare instances where there is something that would warrant the involvement of outside legal counsel, if it's something that's so critical to the project that it has to be figured out in order for the project to be successful, some types of wall assemblies, or if there's some type of innovative sustainability requirement or something else, sometimes it is worth it to go through that process, although even in those instances, it may not play out exactly the way it may be reflected in Master Spec. But a lot of times it's a question about, is it worth going through that process because it's more of a necessity for the project?
Well, so Josh, in that kind of a case, if we're trying to specify a special warranty, does it suffice in the specification then to try to list the items that would be considered a failure, and then the term of the warranty for however long it may be? Is that going to be enough?
You would imagine that in most instances there could be other complications, especially when you're trying to isolate particular products, because there's always something that has the potential to slip through the cracks. And that is the challenge of trying to write some of those types of warranties, is that you're dealing more with an assembly, and when you start focusing on these individual components, it can be very difficult. But that's where it can be to the benefit of the owner to have that correction of work period or something else that is more global in nature for the project, taking everything into account, not being so laser focused on any particular product or isolating different products within the warranty.
I want to go back to that sample special warranty that Master Spec often asks for. My concern is that if architects do not understand that they're supposed to forward that to the owner to be considered by the owner's legal counsel and just sit on it, and something goes wrong, that could work against the architect in terms of its liability. I was the claims manager for the firm that Josh works for now for 10 years, and some of the boneheaded stuff that owners and their counsel come up with, that's not an extreme case by any means.
So if it's something that's more routine and you still have that requirement in there, and it's not foreseeable that you will actually go through that process, it may be worth considering, is that something that needs to be in there if it's not actually going to play out the way it's stated in the documents?
So Josh, go ahead.
Kevin had a couple of comments, or a comment. When considering specifying a special or extended manufacturer's warranty, one, always ask in design if the thing that is the warranty with the coverage that is desired is available, and two, ask what it costs. And that's a good reminder. You know, roofing, those 20-year, 25-year, 30-year roofing warranties are not free, that there is a cost that is built into the cost of the subcontract for that work. And so those are excellent comments from Kevin. And definitely, you know, it's very possible to write warranties that only exist in your head. They're fictional, that no manufacturer would ever do. And so we do need to be realistic.
So, Josh,
that's an opportunity in some instances. When you're asking that question, where does the owner want to invest its warranty dollars? Because obviously there is that cost involved, and that can be where the design professional may be able to provide some input on where the investment would have the most effectiveness, and where would it be most needed, because there may not be available funds to cover everything, but how can you be strategic in assigning what is available?
Melissa Leap points out you need to note that the additional cost for a 20-year roof is not double the cost of a 10-year roof. It's pennies to the dollar for a 20-year.
So, Josh, I'd like to back up to a comment that you were making earlier about assemblies and warranting assemblies. So we've seen an increase in interest of, say, warranting the building envelope as an assembly. Is that something that really is doable through a warranty, since it's involving multiple components, multiple manufacturers? Or is this something maybe we should be considering a bond in place of a warranty?
And we were talking about, in the very beginning of this discussion, we talked about the difference between the warranty and the guarantee, and possibly bringing in a third party, so it's not just the contractor providing a warranty to the owner. And it gets into that question about, do you need some extra support, some extra resources to make the warranty of value? And when you're getting into questions about if something goes wrong, who is going to be available to provide performance under the warranty, that's where you get into comparing what's actually written in the warranty to the anticipated performance. So a lot of times you see, you know, if it's a company who's been in business for only 5 years, but they're providing a 20-year warranty, and comparing that to a company who's been in business for 50 years, but they're not providing the same length of time, and how do you compare that? It's just getting into the next step of that question is, do you need someone who has more of an expertise in sorting out those types of claims? And a lot of times, if you're talking about a bond, you're now bringing a surety into the picture, and are they contributing any more than just providing some type of underlying funds? Are they going to help expedite a claims process, or is there something else that they are bringing to the table in addition to this financial backing? So there are a lot of factors that could play into it, but it's definitely something that we see changing, because we're trying to see what is the future of this discussion. So are there new ways that we will be looking at trying to provide this type of protection that we're talking about, it's definitely something that is now an additional consideration. But if sometimes you don't want to be the first one to try some of these different things, because we tend to gravitate more to the tested means of providing these. So those are a few of the questions that we see when that comes up, and it will be interesting to see is that shifting how we're providing some of these in the future.
Okay. Well, thanks everyone for joining us. We have one last comment from Edward Eistam. Federal government, GSA, once an issue is corrected under the warranty, federal government contracts require that the term of the warranty start over again for that issue rather than continue on the original term or period. Is there a government clause to protect the contractor from excessive claims that attempt to extend the warranty? We don't know. The excellent questions. And do you know the answer to that one, David?
I do not, but I want to know if you know the answer to Zoran Popovic's question.
He wants to know what we're going to talk about next month.
No, he wants to know what we're talking about in March 2017.
Well, I don't remember what we did a year ago.
Well, our presentation says that's when we're making this presentation.
Oh, yeah, it sure is. I'm just slightly behind times. Oh, I'll have to fix that before Matt puts it on YouTube. Good catch,
Well, we talked earlier about having the warranty starting earlier, so that's hoping everybody is watching these dates.
Yes.
Very good. Well, thanks everyone.
So we've predated the presentation, so any implied warranty is now expired.
Expired. That's your 1-year warranty. Well, we really appreciate everyone coming to join us on these discussions. We know that your time is valuable. You're taking time out of your workday to join us, and we try to come up with some things that we think will not only be of interest, but maybe have some benefit to you. And we hope that today's session raised some questions for you to think about and talk about when you're selecting products and evaluating warranties. And a lot of owners have unrealistic expectations out of warranties, and you may need to tell them what's really happening.
We appreciate all of you taking the time on your Thursday to attend. And as David said, we hope to see you again in April on the 5th. Look for that information in email shortly. But also, if you go to the CSI website under the events calendar, it is already listed there with a topic to be determined. So feel free to register now while it's still fresh in your mind. And we look forward to seeing you then. Thanks, everyone. Have a great day.